Hey everybody. Hey everybody. Happy Monday. Okay, I guess people will join. I know they're in a whole nother live, but y'all, it's, show must go on. The show must go on. How are you guys doing on this Monday? I know this is an unusual time for me, but I'm working at home today. So I wanted to do this live, and I was watching the trial, the YSL trial, but they're still on recess. So I tried to push my live back as much as possible, but I wanted to go ahead and just do my live because we're going to cover some good content today. I think it's going to be very helpful for a lot of moms, a lot of just a lot of people. Sorry, I was reading something. Just a lot of people in the community. Hey, Nita. I hope I be saying your name right, girl. I hope I be saying your name right. But I think this will help a lot of people. It'll get a better understanding about being in a community where you have Black men who are recycled in the system, especially in the legal. Okay, good. Recycled in the legal system, constantly recycling the legal system. So at some point, we got to understand how this is happening and why this is happening. So with this situation with, I don't know who's following the trial and who's not following the trial, but whether you are following a trial or you're not following a trial, this is something you'll still understand what I'm about to present. So it doesn't matter if you're following it or not, but because I'll explain it. But this situation that happened with this young man in this trial was a very good example of how Black men get recycled in the system. So I thought this would be a very good example, and it's happening now. I'm not familiar with the trial. Well, is Monday? Yeah, it is. Well, here's the thing. Although you're not familiar with the trial, like I said, whether you are or you aren't, the way I'll explain this, you'll be familiar with this situation within the trial. So, and like I said, it's a good example because I am going to break it down from the beginning to the end, and it's going to come with video so you'll understand what I'm saying. Hey, Kay Monet. Oh, you are? Okay. So you'll know what I'm talking about. So if you are following the trial, this will be good. If you're not, then you still won't be lost at what we're getting ready to discuss. You still won't be lost. So basically, so let me read this because this is going to cover some informational, and I don't want to say anything that's going, my lives are informational and based on my legal knowledge of the law, and at times based on my own thoughts and opinions. I do not speak, excuse me, for any specific party, group, or team. My opinions represent my channel and mine only. I welcome all opinions and comment, but of course, disrespect will not be tolerated. All right, so basically, whether you are not, you guys know the YSL trial consists of a young man. His name is Jeffrey Williams, aka known as Young Thug. You guys know that YSL is his record label. They are trying to claim, the state of Georgia is trying to claim that YSL is a crime organization. Okay. So of course that consists of getting him on RICO charges. Okay. They're trying to get him on murder charges as well, but RICO charges, you have to have more than one person in, the organization. So they arrested a lot of people. I mean, a lot of people. Okay. The main people that they arrested, as you guys, if you guys know or don't know, some of the main people close to Young Thug did take plea deals. They took plea deals because they wanted to get out of jail based on evidence. And you guys know, most of the time, majority of the time, when people take plea deals, it's because the evidence against them is pretty big. And if they go to trial, they're going to get much more than what the prosecutor or DA is offering them. So most of the time, they'll go with a plea deal. A plea deal, most of the time, it'd be probation, it'd be time served, it'd be something much linear than what they're faced with. So basically, there was one heavy hitter in the YSL group. His name is Antonio Sledge, but they call him Mounk Tounk. How do they say his name? I forget how they say his name. So if I'm butchering his name, but he was one of the main heavy hitters in YSL. Well, as you guys know or don't know, this past Friday, he reneged on his plea deal. His plea deal got revoked by the judge. And I'm going to go through as to how it got revoked and why it got revoked. But it did get revoked on Friday, and he went back to jail for 5 years. So what we're going to do is we're going to go back to when he took the plea deal, what the plea deal consisted of, where he went wrong or where they think he went wrong, and to where he got revoked. Okay, right back in the system. 15, 20 instead of life. Yes, exactly. So the first place we're going to start is I'm going to play a video. If you don't know, what's Miss Love she's a black, she's a district attorney in Fulton County in Georgia. Okay. I myself do not like her. I do not like her because she does a little bit of some dirty stuff. I'm not going to lie, but we're not even going to get into that. That's a whole nother video. And that's going to be about Black women in power and how sometimes we can't take advantage of the power that we have. And that's why most people don't trust our judgment to take power, because we allow our emotions to make decisions for us. So that's going to be a whole nother live. And she's going to be an example. The district attorney over Fulton County, which is over her, is also a Black woman, and she is in legal trouble herself. So anyway, that's, like I said, that's a whole nother live. But let's get into Antonio Sledge. Now, this video that I'm about to show you, this is actually them taping the day he got the plea deal. You're going to hear some of the details of the plea deal. Now, I'm going to tell you guys, I would never in my life take a plea deal like this. I would say, give me 1 year, 2 years, throw me in jail. I would never this was a bad plea deal. This plea deal was meant to set him up. You got to know the difference between a plea deal that is good for you and a plea deal that's meant to set you up. Hey, Miss Robin. So everybody listening, I want you to pay attention, attention. Look at how he's answering her, how fast he's answering her, and you make your own judgment as to if he really understood that plea deal. Oh, let me turn this a little bit. You make your own judgment as to see if you really think that he understand the plea deal. So here is them at the time. It's just the prosecutor, the judge, Antonio, and his lawyer. Okay, and they're going over the exact plea deal. So pay attention to what it is. Okay.
Or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 41, 10th grade.
Are you able to read?
Okay. Y'all, and one thing, the guy next to him, that is his lawyer. In case I didn't say that, that's his lawyer, which I don't like either.
Write and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses?
Yes, ma'am.
Conspiracy to violate the Racketeer Influence and Corrupt Organizations Act,
Yes, ma'am.
as well as possession of a firearm by a convicted felon,
Yes,
as
ma'am.
listed in count 30 of this indictment.
Yes, ma'am.
Do you understand that?
Okay, just in case you don't know what his charges are in layman terms, conspiracy of RICO charges and unlawful carrying by a felon. Those are his two charges.
You have the right to plead either guilty or not guilty to these charges, and that if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Derek Wright, about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
No,
Yes,
he's a
ma'am.
paid attorney.
Do you waive a
He'll be
formal
great.
reading of the indictment?
Yes, ma'am.
Do you waive any and all defects in the indictment, including any with respect to your name?
Yes, ma'am.
Have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Do you, Mr. Wright, know of any outstanding warrants that are related to these charges?
I do not.
Mr. Sledge, has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading guilty to
Yes,
today?
ma'am. Yes, ma'am.
Do you understand that this is a negotiated plea of guilty,
Yes, ma'am.
which means that the state will recommend to the court the following sentence?
Yes, ma'am.
As to count 1, 15 years to serve on probation, subject to the special conditions contained in the plea agreement that I have in my hand that I will show you in just a moment. And on count 30, although you are pleading guilty, sentencing will be withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant you have complied with the special conditions outlined in sections B, C, D, F, and I of section 3 special conditions of sentence of this plea agreement, the state agrees that the defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. Do you understand that the court does not have to accept that recommendation? And we will read into the record the terms of the plea agreement in a moment. Do you understand that?
Yes, ma'am.
Okay. So let me tell you what let me tell you what she offered him. On the first count of conspiracy of racketeering, they are offering him 10 to 15 years of probation. He can go home that day and have 10 to 15 years probation. Okay. That's for the first count. Of course, he has conditions with that probation. The second one, which is the gun violation. Now, the way she did that gun violation, this was the setup. The gun violation, in order for them, the gun violation carries 15 years by itself because he's a convicted felon. So that carries 15 years by itself. She tacked another 20 years onto that, which makes it a total of 35 years. So, hey, Love Cat. So what it is when she says they're going to hold off, that means that they're going to make sure that she said that she will drop that charge depending on at the end of the trial, depending on if he agrees to or goes through with the stipulation, what she's going to go through in a minute, provided that he, I guess what I want to say, follows all the conditions of his agreement. So they're not going to give him a conviction on the gun charge until after the trial is over. And their agreement is they will drop it. They won't even charge him with it as long as he does what he's supposed to do on that agreement. Okay. So he'll walk away with just probation. That's it. That's all. With 10, 15 years probation. That's a setup right there. Who do you know? What black man you know with a criminal record? And he has an extensive criminal record that can go without smoking, without drinking. They have a curfew, everything. How many black men do you know, or men, that can go 10 to 15 years without smoking, drinking, going to the club, and that can deal with a curfew when you're 41 years old and you about 50 or something and you have to deal with a curfew? That was a setup for failure from the beginning in my eyes. Okay. So yeah, that was a setup from the beginning. So that is the plea deal. So he's signing to the probation for the conspiracy. And the second one, he will not be charged until after the trial, provided that he goes through with everything on that agreement. So, and that's what he signed. Now, if y'all notice, he's not even paying attention to his lawyer or the prosecutor. He's just looking straight ahead. That's it. That's all.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other if the court does not accept that negotiated plea?
Yes, ma'am.
I just wanna have fun, clap my hands, turn around.
I love that I still look like
All right,
myself.
y'all gotta
but
go to the commercials.
I'm showing you what has been marked as State's Exhibit 1AS. Do you recognize the document in State's Exhibit 1AS?
Yes, ma'am.
And is that your signature on page 7 of 7 of State's Exhibit 1AS?
Yes, ma'am.
And I agree with you, United. He does have a lot of manners. He's very well mannered in this video.
Your Honor, at this time, actually, and Mr. Sledge, have you had an opportunity to review each and every provision within State's Exhibit 1AS?
Yes, ma'am.
As reflected on State's Exhibit 1AS, the current charges that you face are count 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, and count 30, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm, OCGA 1611-133. The negotiated sentence as outlined in State's 1AS is count 1, 15 years on probation, and count 30, sentencing withheld until years on probation, and count 30, sentencing withheld until years on probation, and count 30, sentencing withheld until years on probation, and count 30, sentencing.
We might need to skip forward 2 seconds.
Sorry, y'all. That was actually the people in the court skipping through that video.
Your Honor, I'm going to object. I think they said that the entirety of the agreement is not captured. I'm going to object to skipping forward.
Okay, hold on, y'all. I think, okay, sorry.
Schedule 1, 2, or 3 drug, defendant shall within 30 days of said positive test undergo drug rehabilitation as designated by the court or the Department of Community Supervision and shall successfully complete said rehabilitation program. Defendant relinquishes any Fifth Amendment right related to any statement contained within defendant's factual acknowledgments contained within this plea agreement.
Okay, if y'all notice, she said he has to give up his Fifth Amendment rights. That means that he can't get up on a stand and pull up and say, I don't remember, I don't recall. He can't do that. He has to agree to whatever is in that agreement.
Section 4, defendant's factual acknowledgments. Have you initialed each and all of the defendant's factual acknowledgments contained within this document?
Yes, ma'am.
And is that initial AS your initial?
Yes, ma'am.
The factual acknowledgments are as follows. Number 3, while associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Demikion Garlington and Quindarius Zachary appeared in a video with another person, AS, where defendant brandished a weapon used in a drive-by shooting, and where on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-girlfriend. Number 4, on or about April 28, 2015, as reflected in Fulton County Indictment 15SC 138994, defendant and fellow YSL associates Demikion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in Part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4 of on behalf of YSL and to increase the...
Okay, so let me stop right there because this video is going to lag a little bit, but let me tell you what she's reading. The stuff that she's reading off, she wants him to agree to everything that she's saying. She wants him to repeat all of that stuff in court. She has verbatimly typed up that report and told him how to say it verbatim, and he has to agree. In order to get that agreement, he has to agree to say it exactly the way she has printed it out, or he has to get in court. If she happens to ask him that question, then he has to answer it like that. And it's about 5 of them like that. So in order for him to get this agreement, he has to initial and sign to all of this. And then if he is called to court, he is going to have to get on the stand, and he is going to have to say all of that stuff that she is saying, that the drive-by shootings, he participated in this, he participated in that. He has to get on the stand and say all that stuff if he's called to testify. Now, just because they sign plea deals, that don't mean that they're going to be called to testify. They may or may not be called to testify. So that's what the risk that they're taking. The risk that they're taking is they're hoping that they don't be called to testify. That's why they sign those things, because they always say, if I call you to testify, you got to say all these things. If you don't say all these things, I'm going to put in a request to revoke this. So that is why it is so important in a plea deal that you sit down with your attorney and you do it one by one, line by line. And y'all are going to see how this backfired on him. Them state RICO charges got them prosecutors foaming at the mouth. But they sure is. You got that right. Hey, Ronithia. Yes, now they put him in danger. It was a setup. Y'all, this is an example of how this is the beginning of exactly how they keep people in the system. This is how. First, you're going to give him a 15-year probation. That's going to keep him in the system because you know he's not going to do well on a probation. But anyway, but those are the terms that she's reading. The video is lagging a little bit, so I don't want to keep playing it. But that's the terms. But she's going to say that he has to testify to everything in that paper. And as y'all can see, he's sitting there with his attorney. He has initialed it and he has signed it. So he has acknowledged that he has initialed and he signed it. Okay, now I blame his attorney. But y'all are going to see. So now I'm going to play the video of where it goes left. Okay, I'm going to show you where they actually called him on the stand, and he's like, I ain't agree to all that. I ain't agree to all that. So, but if you were in here and you heard it, that he said, yes, ma'am, but I told y'all to pay attention to the way he looking. He's not even hearing her because he's just saying, yes, ma'am, and she don't even complete sentences. He'd be like, yes, ma'am, yes, ma'am. So, but anyway, the next video is going to tell y'all exactly what really went down with that plea agreement.
Yes, I think so.
Do you recall
Now, this
being
is
asked
him
whether
on the
you felt
stand.
intimidated to sign that plea agreement?
I don't recall that.
I'll ask you, were you intimidated by the state into signing that plea agreement?
Was I intimidated?
Were you intimidated?
I wouldn't say I was intimidated. I was basically like, I just feel like it was forced on me at the time. I wasn't intimidated by it.
It was forced on you. We're going to come back to that word force, okay?
Yes.
Do you recall on direct examination when I was asking you questions, do you recall you first mentioning something about the fact that your mom, unfortunately, had become ill? Do you remember that?
Yes.
Do you recall telling me not to speak on her?
I said I didn't want to talk about her.
Do you recall Mr. Steele asking you about her multiple times?
Yes.
Did you have any problem with him talking about her?
No, because me and my lawyer discussed, don't even get frustrated about it.
So is your testimony that?
Yes, he just told me to stay focused in.
Okay, all right.
Even with you, he just said, stay focused in. Answer the questions.
And tell the truth?
Yes.
All right. When you say you felt forced, would you please tell the jury who it was that forced you to sign, or who you felt forced you, if anyone in particular, to sign anything on December 28, 2022?
I say the state because
Hey,
when
Kimberly.
I addressed it and tried to change situations, they wouldn't change them. So,
And it's still your testimony. Is it still your testimony that there were things that you wanted changed that you did not get changed? Is that still your testimony?
Objection asked and answered.
Oh,
could you repeat it?
is it?
All right, so this is what is going on right now. He says that when they got the original copy of the plea agreement, that there were some things that he did not agree to. He says that he went back to his lawyer and asked his lawyer to email Miss Love to change some things. At first, he said she changed it. Then she went back on the day that y'all just seen, and she went back to the original, but he still signed it. And this is where I blame his attorney. He still signed it. And she's talking about his mom because you will see that he, well, no, because I don't have that clip. His mom was really sick. So he had just been informed when he was in jail that his mom was ill. So he just wanted to get home to her. That was his reasoning to even signing the agreement. But my thing is, when she made the changes, the draft came to them, the attorney claimed, that he looked over it. They was good with it. They sent it back to her. Then she sent it back the next day and they signed it. And the attorney didn't bother to recheck it to make sure that everything was okay. And he had this man sign it. Knowing this man has said many times that he has a 10th grade education and some words he does not understand. He does not understand some words that they were saying that's in the agreement at all. And so his attorney was well aware of that, but his attorney sat right there and allowed that man to sign that. Because there were things in there that he said he was not going to admit to, that she wanted him to admit to, but he said he wasn't going to do it. So that's what they're talking about right now.
It's still your testimony that there were things you wanted changed in this plea agreement that you did not get changed.
Yes. Your Honor, can I talk to my lawyer right there?
You may.
All
right, let's just take a recess.
When you spoke with the police back in 2015, did you tell the police any of those things that you told your friend, Defendant Williams' attorney, and your friend, Defendant Stillwell's attorney, when they asked you questions on cross? Did you tell the police any of that stuff?
I don't think they asked me nothing like that.
You
I don't recall them asking me nothing like that. You said the police?
Yes, sir.
I don't recall them asking me nothing like that. What Mr. Steele asked me.
Do you recall Mr. Steele asking you about that drive-by shooting?
Oh, Robin,
yes.
Robin, she's
Do you
mad
recall
now. She's very mad.
the police asking you about that drive-by shooting?
Yes.
How much information did you give the police about that drive-by shooting?
I told the police it wasn't true.
Okay. Now, okay, so, and when I asked you on direct examination about that drive-by shooting, what did you tell me about that drive-by shooting?
I don't recall. You can refresh my memory.
Do you recall me asking you what you did before that shooting?
I don't recall it though.
Do you recall me asking you how did that shooting happen? Yes.
Relevance, ask and answer.
I can show you. I can respond.
Overruled.
That you dropped off Quindarius Zachary and Demekion Garlington and left and don't know what they did after you left?
I don't recall it.
Okay. Do you recall me asking you about another house getting shot up on Drew Drive after the house?
Yeah, what she doing is she asking him questions that was in the plea agreement and seeing how he's going to answer. That's what she's doing right now. And right now she's pissed off because he's reneged. She's pissed off because he said that she forced him to sign that in front of the jury. So that's why you see her acting like that. She's really pissed.
On Adele getting shot up.
I don't know in what article. I don't know the addresses.
Do you recall me asking you about whether you saw or participated in any other house getting shot up other than the house off MLK on Adele Drive? Do you recall me asking you that?
I don't recall.
So do you not recall as well telling me that you didn't see any house get shot up?
I don't recall me telling you that I seen house get shot. I don't recall.
Now, what I just heard you say is, I don't recall me.
Me telling you that.
You don't recall you telling me what, sir?
I just don't recall, Ms. Lord. I don't recall.
What is it that you don't recall? I'm sorry, I need the jury to know.
I don't recall.
What don't you recall?
I don't recall. I don't recall. You've been pushing me so much, it's like, I don't even be remembering a lot of stuff you said.
Yo.
Was your friend, Mr. Stillwell, here in court with you on December 28, 2022?
No.
Was your friend, Defendant Williams, here in court with you on December 28, 2022?
No.
Was your friend, Defendant Kendrick, here in court with you on December 28, 2022?
No.
Was the lawyer for your friend, Mr. Williams, here in court with you on December 28, 2022?
No.
Was the lawyer for your friend, Mr. Stillwell, here in court with you on December 28, 2022?
No.
Was the lawyer for your friend, Mr. Kendrick, here in court with you?
So let me tell you, she's trying to be funny right now, y'all. She throwing shade. She throwing bad shade. And basically what she's doing is she's trying to make it seem like the reason why you're changing your story is because you got people up here in this, you got, Young Thug and all of them sitting in the back looking at you. That's if you notice, she's trying to be shady by saying your friend. Now, I don't understand why they didn't object to that, because that's, her saying that because she's classifying them as her friend, as his friend, when, he's already said those are not his friends. But I don't know why they didn't object to that, because I would have objected to it. But I don't know why they didn't, because she being real shady right now.
On December, he objected. Hold on, Mr.
Relevance to whether I was in attendance at the time he took his plea.
John, was the lawyer for your friend, Mr. Kendrick, here in court with you on December 28, 2022? You can answer first, and I will let you explain, but I need you to answer yes or no.
But could you stop yelling at me like I'm your child or something? I'm not your child.
You are not.
You talking aggressive to me. You don't intimidate me. All them guys over here. So if you would have came to me and asked me that, I'd have told you the same thing. What if they was in my face or not in my face? I'm not scared of them or you.
I don't want you to be.
Well, that's what you acting like it. That's what you acting like you're trying to
So
fight.
do you want me to bring my voice down? And I apologize.
Don't
if it
holler at
sounds
me.
like
I ain't no child. Can I take a break? Y'all call.
No, we've had so many breaks this morning. We really need to get through this.
on last week when I asked you specifically about portions of what you agreed to, and for you to tell me if any part of it you're now testifying is false, to label it false, and if any part of it, if it's all true, to tell me it's true. Do you remember me having that conversation with you?
I remember the conversation, but you ain't put so much on. I don't even recall what went on.
Do you remember me putting in front of you State's Exhibit 447Y? And
Yes. Oh, okay. All right. Whether he remembers it or not is not really the relevant matter.
Oh, God.
All right. 1AS, did you testify that number 3 under defendant's factual acknowledgments is not entirely true?
No, I didn't say it was not entirely true. I think I remember I said the part of the support of YSL, and you put Kill as a robber gang, and I told you I didn't even know he was that gang at the time. And if I made a mistake anywhere else, I made a mistake.
All right. Do you remember me putting, now I have to ask, do you remember, Your Honor? Do you remember me putting State's Exhibit 444Y in front of you?
I remember you putting all these papers in front of me, but I'm like,
do you remember me asking you to go over each number, and if one of it is true or one of it,
oh, go ahead.
do you remember me asking you that if all of the statement is true, to tell me and label it true, but that if any of it is not true, to call it false? Do you remember that?
I don't recall that, Ms. Love. Like I told you, you've been confusing me for so many days. You've been confusing me since I've been on this thing. So I don't know, like now, you jump from one thing to another thing. My brain don't move as fast as probably yours. I might don't learn as quick as you do. So I don't remember all this stuff. You putting all these papers in front of me ain't gonna make me remember.
Okay. All right.
So I don't remember all this stuff. You putting all these papers in front of me ain't gonna make me remember.
Okay. All right.
So whatever you're trying to get to, get to.
All right. We're just getting to the questions. So on cross-examination, the witness was asked whether he was allowed to craft this, whether they were his words, whether he understood them, whether he felt compelled to.
I recall.
And so what I'm asking now, and he was also asked on cross whether he felt between a rock and a hard place.
I already answered that question.
So what is it that you want to ask him?
I believe that he testified on cross that one part was feeling between the state and the other was Fulton County Jail or going back to jail. So I'm asking him about his sentencing acknowledgments and what he has stated or agreed to within the sentencing acknowledgments, and how that squares with his rock and hard place on December 28, 2022.
Okay, then ask him that, how those acknowledgments square with his rock and a hard place.
I don't think that's going to be a quick answer, but I'll ask. Okay, so Mr. Sledge, how do your sentencing acknowledgments square with, do you understand that you
now you thinking this stuff funny.
No, sir, I don't.
You do you understand? But I know your question ain't funny.
It is not.
So what you laughing for?
Mr. Sledge, do you recall
Honor.
Mr. Sharp as far as coming in here and testifying to something different than what you put in the factual acknowledgments?
I came, from my understanding, I would be able to explain the things that you wouldn't change. That was from my understanding.
Okay.
So now I'm here testifying my truth and not what you put on paper and your answer. These is not my answers on this paperwork. Yeah, I did sign it, but if you would have came to me personally, like I think you should have did, and asked me this yourself, I would have told you no.
Did you testify that lay low were my words and not yours when I asked you on direct examination about defendant Williams giving YSL members money to lay low after the murder of Donovan Thomas?
When you asked me at that meeting, I told you he couldn't have gave YSL money to lay low because I'm the only one that stayed in Atlanta. No. I told you he gave me money to get out of harm's way. I borrowed $300.
I'm talking about in court last week. Do you remember saying, I didn't say lay low, those were your words?
Them is your word. I didn't say lay low. That was already on this paper. I never used the word lay low to you not one time. All this stuff that you trying to say, it was already on the paper. You changed certain things and then we agreed. And then I'm going to be honest with you. I didn't even want to say that. I got another paper that's saying you changed number 8. It went from one thing to another thing. You don't want to red flag that?
No, I do.
Okay.
So thank you.
Because you changed the personal knowledge and I ain't changed it.
Thank you for that.
I would have never said yes to that. When I got to the last paperwork, I thought we had an understanding of what the emails my lawyer sent you.
So do you now remember getting multiple versions of State's 444Y that was changed at your request?
Not all of it.
Okay. Well,
But all these are capable lawyers, as is your lawyer, so
Yeah, but she,
I just call the balls and strikes.
you silly.
all right.
I swear you is.
Just one moment, Your Honor.
She's silly.
I think she's almost done.
Yeah, I hope so. Before I go back left. Cause I don't mind going left.
Oh Lord.
What do you need to say? Go back left.
Arguing back and forth with you.
Okay.
You just being petty now.
Oh.
All right. You felt differently on December 28th, 2022. So, do you remember asking the state to change more than one thing on the factual
A
acknowledgement?
lot of things.
Do you remember the state making changes at your request?
I don't really know because I seen something different today than it wasn't what I thought it was the day I agreed.
Do you remember last week testifying that you hadn't seen any other document besides the one you signed?
I just seen them today.
Okay.
I didn't see it. My lawyer was just coming, asking me, and I guess he thought the question was going to be changed, and I don't know. I don't think they was changed.
Okay. Well, we'll get to that. Since you won't remember, that's fine. Where you halted the proceedings, or what wasn't seen. Did you ever halt the proceedings on December 28, 2022 to ask to speak to your attorney?
I don't even know the words you just used.
Did you ever stop and say, Judge, can I talk to my lawyer like you have today and last week?
Like I told you earlier, I ain't sitting over there. I'm sitting up here supposed to be telling my truth. And it's like you're not accepting my truth. I wasn't sitting over there in County Blues. I was sitting over there in County Blues. I'm in free world. So it's like, I couldn't stop and say that over there.
Why couldn't you?
Because I don't understand that. But once I got up there, I thought I could. Because you told me that. You said, anything you don't understand, you didn't tell me that December 28th, right?
Did your lawyer?
No. My lawyer didn't tell me that either.
So sitting next to your lawyer, did you ask him questions? Not talking about what they were, but did you ask him questions at the table?
I would ask the witness to be allowed to answer the questions.
Judge, I'm not asking him what was said. I'm asking him.
The province of the what? Oh, no, that doesn't. Overruled.
Sitting at the table next to the lawyer you had known for 15 years,
So rude.
were you able to ask him questions?
I probably could have, but I didn't.
And in the back, when you were with the lawyer you've known for 15 years, did you ask him questions?
Yeah, I told him.
Well, if he wants to share it, it's his to share.
I don't want to share it. Okay, I don't want.
Specific about what you and your.
I don't want to share it.
And I'm not asking you what. I'm
I
asking
don't
you,
want.
did
She
you?
just said I had to share it.
She said you didn't have to share the content. I'm asking
Well, I
you.
don't want to share it. I don't recall. No.
All right. You felt differently on December 28th, 2022.
You would have changed everything I want you to change. I probably wouldn't be going through it. You probably wouldn't have gave me the deal. If you'd have came and asked me. Oh, man, I'm sick of it, man.
I don't want to make you sick. Okay?
Well, let me take
Who are
a
you talking
break.
to right
Can
now?
I take a break?
Hang on just a sec. Are you almost done? Because
I'm wrapping
there are
up.
some people who need a restroom break.
Okay. Okay. So they get ready to end right there because they're getting ready to take a break. So let me say this to y'all. I know y'all think, oh, she is so rude. Y'all ain't seen half of this lady in action. Y'all have not seen half it. So if you're not following the YSL trial, then you need to go follow it because this lady is a whole mess. When I tell you, this was just a small side of it. She argues with judges. Everything. But anyway, so in this particular one, what she was doing was she was trying to break him back down. She was trying to ask him stuff from the plea agreement to see if he was going to acknowledge it, own it, or whatever he was going to do. He said, I don't recall. And you see him jumping on her saying, if you would have changed it, then I would have did this. Hey, Terry, if you would have changed it, then I would have did this. If you did. So he kind of arguing with her because he's pretty pissed off at this point. You know what I'm saying? So, but here is the downfall for him, though. The downfall for him, though, is that At this very moment, she has the power because she can revoke his plea agreement because he's not cooperating. He, regardless of anything, he was supposed to say exactly what she wanted to say on that stand. But here's the thing, it's always a way to do that. This is what you do, to stick to your plea agreement, but at the same time, let the jury know you was forced to it. And the way you do that is, and don't tell nobody I'm telling you that, but when you get up on a stand and somebody tells you to that you needed to say this, and you remember, oh, I'm supposed to say this or I'm going to lose my plea agreement. So if somebody said, you better say that pillow was pink, okay, and darn well it's red, all right? So you get up on a stand and she says, hey, what color was that pillow? She expecting you to say pink. Your thing is, do you want me to tell the truth or am I supposed to say what I'm supposed to say? You can get away with that. You can get away with that because he took an oath to tell the truth. They're trying to confuse. Yes, they are. So that's how you outsmart a DA. That's how you outsmart and still keep your plea agreement. Are you saying, do you want me to tell the truth or do you want me to say what I'm supposed to say? And if they say, I want you to tell the truth, then they just told you that you needed to tell the truth, right? That's how you outsmart a DA. That's how you keep your plea agreement. That's how you keep your plea agreement. And at the same time, you keep your integrity and you're not up on the stand lying. That's how you are letting the jury know that what you're saying is not true. You're saying what you were told to say. So I believe that he could have went a different way with that to not lose his plea agreement. But I blame his lawyer because his lawyer should have went through that with him one last time. And if there was something wrong with it, then he should have, in fact, made her go back and change it again. So his lawyer, to me, his lawyer and the prosecutor set him up for failure. They set him up for failure because he wasn't finna get in front nobody and say all that when he knew it was untrue. Now, you guys got to go check out the YSL trial for that whole video because Brian Steele, which is Young Thug's lawyer, gets up there and questions him and breaks it down line by line, everything that the prosecutor told him to say, and he turned around and he corrected it and put in the right information. Y'all got to really see that. I was just blown by the way she twisted up them words. She really twisted them up. But right there, y'all seen a very pissed off prosecutor, but y'all ain't seen nothing yet because she gets really pissed off. And I'm going to do a whole separate video showing every time this lady has went off, if StreamYard would stop acting up. So to recap, y'all seen where he signed his plea agreement, and you have to agree he initialed and signed with his lawyer sitting there. Whether it was wrong or not wrong, you seen him sign it, you seen her read it out, okay? Now he's on the stand, and we get the backstory that says there was things that were supposed to be changed. They were not changed. She's pissed off because you were supposed to agree to it, and now, boom, you up in the air getting ready to get your stuff revoked, which brings us to what happened on Friday. So I'm going to bring that up. I hope I'm not going too fast. Y'all, I hate these videos when they act up like this. But now we're going to bring, which is to present day, and you're going to see his attorney try to explain their way out of that. Because regardless, y'all, you got to go about it a different way, because once you sign a legal document that a judge has signed, you kind of stuck. And his lawyer should have had sense enough to just advise him better. That's what I feel. But, so this is the beginning. They took Miss Love off of this hearing, and another.
The sentence that he received from Judge Glanville on December 8th of 2023 as it relates to his reviewing, acknowledging that the factual acknowledgments that were a part of the plea agreement he entered into on December 8th of 2023. I have a certified copy of the conviction, for your honor, with a certified copy of the indictment, as well as a copy of the transcript of the plea that was taken on December 8, 2023. An exhibit within that plea transcript is the plea agreement, which includes the sections, I believe it's sections 4 and sections 5 of the plea agreement as it relates to the factual acknowledgments that the defendant swore under oath during the plea that he had reviewed, then initialed each one of the factual acknowledgments, and then signed that he, again, understood and had reviewed each one of the acknowledgments that he initialed as part of the special conditions of his plea, that when called to testify, if called to testify, that the specific factual acknowledgments within the plea agreement were true and accurate statements, and that would be the testimony that he would provide as it relates to his witness testimony during the trial of this case. So I would present to the court State's Exhibits 1 and 2, as well as a USB drive of the defendant's testimony on day 124, 125, 126, and I think 126, Your Honor, but all of the defendant's testimony can be found on State's Exhibit 3. As everyone is aware, Your Honor witnessed it and can take judicial notice of everything that occurred during the testimony in which Mr. Sledge did testify. And I believe the court during, I think it was day 125, helped direct the defendant to sections 4 and 5 of the plea agreement during the testimony for him to focus on and read and to go one by one and acknowledge or disavow is the only word I could really think as to being no longer true and testifying under oath that he was violating the special conditions of his probation, Your Honor. So this time I would tender State's Exhibits 1, 2, and 3 for the court.
All right, I'm not quite sure I understand what 3 is.
3 is a USB.
Your Honor, may I remain seated or?
It's probably easy. You can. It's probably easier to hear you that way.
Okay, I think I'm on. Your Honor, if it'll please the court, I believe, and I have already sent to the court defendants 1 through 6. Defendants 1 through 5, I believe, were already, I think my emails between myself and Ms. Love came into evidence during our testimony.
Came into evidence in the trial of the defendants that are on trial right now.
Yes, Your Honor.
Yes.
So those are sort of resubmissions of those, but I do think they're already before the court, or the court can potentially take judicial notice of that.
What is your Exhibit 6? I think I only got 5.
Exhibit 6 is the one thing, and that's just a listing of my emails in December between myself
Oh, that's
and
this one page?
Yes.
Okay, it didn't have an exhibit marker on it.
I'm sorry,
so
Judge.
That's fine.
And, succinctly, I these exhibits. When you look at Exhibits 1,
And those are admitted for purposes of this record, which is the probation revocation matter.
Thank you, Judge. When you look at Exhibits 1 and 2, what you see going on is plea negotiations in this case started on December 27th between myself and Ms. Love. You can see it's in the evening hours, And that's one reason I wanted to make sure that the sort of the cover page, along with the attachment, are part of these exhibits. At approximately 4:57 p.m. is when the email first comes in from Ms. Love. You see that the second one, defendants 2, comes in at 5:06 p.m. And at some point I respond. Those are the only 2 exhibits or the 2 drafts which occur on the 27th. However, it's important to note that when you see the response that I send to the email at 5:06, I send that response at 8:42. And I point out specific issues with the draft that need to be revised.
Right.
Now,
yeah, and I recall we discussed this during the trial of this, the ongoing trial as well.
Yes, Your Honor. And the point I won't belabor it is these revisions you actually see being put into the drafts. So by the time you see defendants 3 and defendants 4, they note that there's attachments updated to. You see that those very revisions that we requested are being put into the actual drafts. And ultimately, it was Defendant's Exhibit 4 that if you look on Defendant 6, when the email comes in, it says, use this one. Mm-hmm. That is the agreement that we thought we were executing on the 28th. And remind you, on the 28th, we're in court. This isn't where I'm at my office. I can print it out, look at it, take it to the client like we did on the 27th. On the 28th.
On the 28th, both you and Mr. Sledge are in person in this courthouse,
correct.
Right?
So the emails, if you notice, I never respond because I'm here. I'm in person.
Right.
So we would get it and via phone, or if they would give me a draft, to take to him, I would literally go from the conference room back to the holding area. We would go through it, go over it. But the one that we thought was going to be the executed final was the same one that they said on Defendants 4, use this one.
But are you testifying now, or are you just recalling for me the testimony from previously during this ongoing trial?
I am asking the court to take judicial notice.
I will take judicial notice of what both you and Mr. Sledge testified to in the trial. I recall it.
Understood. So ultimately, the last thing that I think we mentioned in our testimony was where we did take issue with some things. We said he'll have a chance to answer the question and to explain. Now, there was a big problem, and I noted in my testimony that number 8 on that version that got signed had been taken out, removed. All of a sudden it reappears and it's there. My client initialed it. Yes, it was tendered. But ultimately, here's the problem. My client has always said he does not know who's responsible for shooting the victim, who he never was a participant or heard about planning the murder of the victim. And therefore, number 8 was put into evidence by Ms. Love to the court when it was a knowing statement. She knew that statement was false. That is,
I'm not sure about that. That may be your contention. But...
Well, we would contend to the court that where my actual email Defendants 2 clearly denoted that.
It does not. That is up for debate what that denotes.
It is removed from all the drafts and then ends up back in.
That is true.
So.
But your response on your Defendant's Exhibit 2 to what is then item number 4 does not definitively state anything like what you just said. Okay. He said he did not know, as we discussed at the time of the ongoing trial, could have been interpreted in several different ways. But I understand what you're saying.
And just so
you maintain that just
Okay, so yeah, I paused that, y'all. So let me tell y'all what I think from that conversation. Now, I deem Judge Whitaker, she seems to be a very fair and logical judge. I don't deem her as biased at all. But I'm going to tell you, just based on that conversation, seems to me that the lawyer actually did not do or press the issue the way he should have pressed the issue, because apparently his email is not what it claims to be. It was very broad and it wasn't specific, and it didn't tell her that she needed to do this way, this or that way. That's according to Judge Whitaker. Now, like I said, based on me watching the YSL trial, Judge Whitaker has been a pretty fair judge. To me, she's fair and she's logical. You feel like you think she's biased? I don't think she's biased, because I don't think she likes the prosecutor. I think she does not like Miss Love. That's why Miss Love didn't do, because my understanding, they thought that if Miss Love did the hearing, that she would not punish him or whatever. So that's why they got the junior prosecutor to do the hearing. But I just don't think that, I don't think that he me personally, I kind of blame a lot of this on him.
You both missed the fact that you signed, or your client signed, a factual acknowledgement that included item number 8.
Correct.
And then when Miss Love read it out orally in the court, and Mr. Sledge one by one said, yes, I acknowledge that somehow that didn't occur to you at that point in time either. So I understand what the assertion is. Here's the thing. You seem to be focused almost wholly, if not wholly, on, well, maybe there was a mistake with regard to factual assertion number 8. The issue that I see is that the state has not limited their petition to revoke probation to, he contradicted or he refused to acknowledge during the trial that item number 8. It is the entirety of disavowing factual acknowledgments, etc. And what got disavowed under oath in this trial was far more than just item number 8. It was item number 3, item number 4, item number 5, item number 6, item number 7, item number 8, item number 9, item number 16, and then the part 5, sentencing acknowledgments, number 1, number 2, number 3, number 4, number 5, number 6, and the paragraph underneath asserting that he's read and that they're true and that he understands that he's had an opportunity to discuss it, and he voluntarily enters into it, et cetera, et cetera. So even if we entirely disregard item number 8 of the factual acknowledgments, there are still however many other ones that added up to that the state is still relying upon. And I don't see how you get around, and maybe you have a way to get around the rest of it, and I'm certainly willing to listen, but that one thing is sworn to in open court on December 28th of 2022, and then something diametrically opposite of that is sworn to under oath back on September 5th of this year.
I understand your concerns, Judge. One of the things that we traveled on after taking the plea was he would be able to explain his answers if he had issues.
Can I ask you a question about that? Is there anywhere in the guilty plea agreement in sentencing of your client in December of 2022 where you reserve that, where anybody, the state, the defense, or the court puts on the record that that's part of the understanding?
It is not in the written plea agreement, no.
All right.
However, in
You see what I'm saying? That should have been in the plea agreement. That should have been in the plea agreement. And that's something that your lawyer would make sure that he has your best interest and has an understanding. So this is why I say that I blame his attorney, because those little details would have made a huge difference. And he didn't put them in there. He just didn't. So, this is where lack of care, lack of interest, just lack thereof from the attorney, that he didn't read that. He didn't read it carefully. He didn't break it down, and he made his client believe that he would be able to get on the stand and explain his answers when in fact that wasn't part of the deal. So right. It just wasn't. So that's just why I kind of lean toward, and I always, if you are represented by an attorney or a legal, they don't know that stuff. The client doesn't know that stuff. Hey, Trini, the client doesn't know that stuff. So it's up to the attorney to educate them on and make sure that they know what they're signing. So so this guy was under the impression that, hey, listen, even though this is written this way, I'll be able to get up on the stand and explain it. So the lawyer is kind of, to me, twisting his words, because Antonio said that his attorney told him that although the changes were not done in the agreement, he made Antonio believe that he could get up there and explain it. And when in fact that was a lie, because it wasn't in the agreement. So, that's my take. I just think he just did him bad. He just did him wrong. This right here, Antonio's going to have to look at his lawyer for this one. It was nobody's fault but his, because he should have made sure that that plea agreement was intact and straight, and because he know his client was going through some things, and he just didn't do that. Not to me, that's my opinion. That may not be, what somebody else think, but even the judge called him out on it. And most of the time I'm not a judge person, but I have to agree with, she asked him, was it in the plea agreement? No, it wasn't. So
in evaluating my client for the purpose of this hearing, I don't think the state is denying that that is something that it was understood. Understanding it's not in the written plea agreement, but it was understood. And the other thing to also take note of, my client, when asked to make himself available,
if you're looking to get a credit card that helps you earn points to travel this summer, I would think about two things. First, what's the welcome bonus?
My client, when asked to make himself available, to meet with the state, to be prepared by the state, at all times would show up and do that. He was never provided or questioned it with any details, such as, here, let's go over your plea agreement, these factual allegations, what questions may be asked. In other words, what you saw at trial was someone who now, after December of 22, was now for the first time being drilled, or asked questions rather, as to the specifics of all the things that he had allocated, all the questions that were going to be asked. There was no preparation of him. So what you saw was probably frustration on his part at times, and shutting down at times on his part. But it was also part of the manifestation of what happens when a witness, who's not a lawyer, who's not someone used to this, is getting questions fired at them. And at some point, I think the court can take note that he literally shut down. And some of what the court saw may be more of a manifestation of being overwhelmed, as opposed to trying to purposely change or diametrically say something different than what ultimately he allocated initially. So I, in retrospect, wish the state had actually, more than general questions, actually prepped him like you would normally see a witness be prepared and prepped. That did not happen. So you saw a very raw witness recounting things that happened quite some time ago and did not necessarily say things consistent with what he said before. It wasn't simply for a malicious intent or an intent to deceive. There were several factors, is all I'm indicating, that may well explain.
Okay, so I'm sorry, I had to stop it again. So he's very well right. When a prosecutor has a witness or they have made a plea agreement with a witness, they will usually prep the witness, which means they will sit and they will talk and make sure that they're on the same page before they put them on the stand. So that does happen. However, it is up to the attorney to make sure that that meeting happens. The attorney is not supposed to allow his client to take the stand until that he has made that meeting with the DA or the prosecutor to sit down and prep him properly, him or her properly. So again, to me, he's putting his job on the DA because it's up to him, because he's the one that's got to protect his client. He's the one that understands how the system works. He has to call the DA, call the prosecutor when they say, hey, listen, we need your client to come and testify. So the next question for the lawyer to the DA is, okay, so when are we having our meeting? Because we need to sit down and we need to prep him. We need to go over everything to make sure. That didn't happen. So this is the result once again.
Why it was so difficult during his testimony.
All right, anything else you want to present?
Your Honor, not at this time, no.
All right. Can the state give me a quick rundown of what this defendant's prior history is, including any prior probation violations? And then I guess I know that the probation officer is on here, so I'd probably need to at some point ask that officer if they would like to be heard as well.
And Your Honor, we would defer to probation as it relates to, I know they have a full account of his history as it relates to.
You know what, I think I'm still on Zoom.
Yes, Judge.
Yeah. And what's the officer's name?
That's Jolly.
Oh, it's my regular probation officer from long ago, whom I haven't seen in the last 2.5 months because I've been otherwise occupied.
Hello, Judge Whitaker.
Hello, I'm trying to, oops. Okay, I'm trying to get myself on video. I know. So that it's not a disembodied voice. Hang on. All right. Hello, Officer Jolly.
Hello, Judge.
All right. What is probation's? Can you give me a rundown of Mr. Sledge's criminal history? And I'm sure you heard the question I just asked, as well as any prior probation violations.
Well, currently, he'd used his first offender twice, one for DeKalb County, one for Fulton County.
Well, that's lucky. Since you're only supposed to get to use it once. Okay.
Yes. So the DeKalb County case 04CR24799, that was theft by receiving stolen property, felon in a obstruction of law enforcement officer, which was a misdemeanor. That was May 19th, 2005, I'm sorry. He used his first offender. The second case, 04 SC 23883, that's Fulton County. He used his first offender. That was possession of cocaine, as well as a possession with the intent to distribute cocaine. That was December 10th, 2004. The possession with intent to distribute cocaine in Fulton County was January 3rd, 2014. Again, both times, all three times, he used his first offender. The next case is 15 SC 138994. That is a Fulton County case. That is the gang participation, aggravated sex battery, attempted aggravated sex battery, aggravated battery, aggravated assault, criminal damage first degree, criminal damage second degree, and possession with a firearm by a convicted felon. That was January 10th, 2018.
All right, so given the fact that he had at that point a possession of a firearm by a convicted felon, does that indicate that at least one of those first offenders was not successfully completed?
One
Or are we
moment.
missing a felony?
One moment. In addition, of course, the current case that he is currently on probation on. As far as previous revocations,
So, hang on. So the 15 SC and then this 22 SC case, right? Is there anything
Correct.
between the two of them?
There's nothing in between the two of them, no.
Okay.
You guys, I'm switching over videos.
He's pulling that up. There is a third C.
Yeah, the only documentation that I have regarding a revocation just said revoke closed July 16, 2008. Doesn't really show any actual time served or any time being revoked or continued on probation back in 2008.
Okay.
So I'm unsure if that's an actual revocation that was completed.
Okay, well, yeah, it sounds like maybe it was revoked, but it was just wrapped up in something else is how I would take that. I don't know. But, or that that a violation was found, but we don't know what that was.
To the courts to make that decision.
Okay. All right. Well, I find there to have been a violation as alleged, and again, even discounting the item number 8. What is the state's recommendation?
In full candor to the court, Your Honor, I'm going to leave it. The state is going to leave it in the full discretion of the court. Your Honor is fully aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case. And I'm going to let Your Honor be the full steward of deciding what the penalties should be as it relates to all of the time that Mr. Sledge still has remaining on probation.
All right. Well, I know that at least I believe in the petition for revocation, the request is that the entire 30 years be revoked. Is that right?
It's not the request.
Oh, you're just telling me that's what he has at this point, although it can't be all of it, right? I mean, he's been on probation for at least a couple of years, and did he serve it? What's left?
He just started on December 8th of 2023. I think he got credit for the time. I think he was in for 2 years, so he would have 26 and change or 25 and change.
I'm sorry, correct, 22.
My bad.
The exact number. That would be 27 years, 7 months, and 8 days.
All right. All right, thank you. Anything else from either side?
No, Your Honor, nothing further from the state.
Okay.
Your Honor, if it will please the court, I understand the court's ruling that there is a violation. Ultimately, I guess to some degree, while it's not clearly akin to a substantive versus technical violation of probation, it is a non-violent, non-new offense kind of violation. And I would say if the court is going to violate my client, it would be more germane to treat it as a technical violation. We have expressed to the court different thoughts and reasons for the way the testimony came out. We don't know what effect, if any, one way good or one way bad, that has had. But in terms of his violation, I would ask the court treat it more as a technical. He has one grandchild on the way, one that just came early this year with Ms. Jaquila Freeman. So the point is, he has been staying out of the way. He's been complying with probation. I would ask the court to maybe consider if you want to put more restrictions and make his probation much more of a, not just something he's on, but something that now has more teeth to it because he's been working. He's been taking care of his family. He's staying out of trouble. He's turned that corner. And literally, it was always our hope he wouldn't have to come in and testify. And there was a reason the state allowed this plea to go forward so that he could step away. And in doing so, if you recall, you may have remember from his testimony, by no fault of his, he was a victim of a crime where he was shot multiple times and had to recover from that. So we would ask the court to consider some restrictions first, as opposed to custody. And if you do go with custody, we would ask to consider it as a technical type of violation, not a substantive violation in which you would be authorized to give him an even greater sentence. So we would leave it in the discretion of the court, but we're asking again for a non-custodial revocation punishment.
Okay. I don't view it as a technical violation or akin to a technical violation, considering the solemn oath that he took when he said that he understood every term within the plea agreement, factual acknowledgments, and sentencing acknowledgments, and understood and, in fact, orally answered that he understood when both asked by the prosecutor and the court at his plea hearing that failure to abide by any of the terms would constitute a violation of the agreement, and he was notified that the entirety of his probation could be revoked. I do appreciate the fact that this particular violation is a non-violent violation. But I also appreciate the fact that some of the many why this could have occurred include the fact that there is just not a proper regard for the judicial system and the seriousness with which an oath in court needs to be taken. I actually view this much more akin to perjury, frankly, than a technical violation. And the sentence for perjury is up to 10 years. I am going to revoke 5 years of Mr. Sledge's probation. And Mr. Sledge, I am sympathetic to the fact that you have generally stayed out of trouble, and I want to commend you for that. And I really hope that this revocation doesn't set you back. But
okay, so I'm gonna stop it right there. For her to say that I hope that this doesn't set you back was a whole joke, because what she did was she gave him 5 years off of his probation, and he got to serve that in custody. But even when he gets out of custody, he still has to remain on probation. So he didn't win either way. So that's, to me, how he's going to constantly get recycled back in the system. I don't care what he does. He's going to get back out, and he's going to have at least 5 or 6 more years of probation left. So that opens up the door for more issues and more problems, which that is an example how they get recycled through the system, as they're going to keep them on paper. As long as you're in the system, you're going to keep going back and forth, back and forth. That's how you stay in the system. And once you're in the system, it's hard to get out, especially when you're involved in something like this. Now, do I believe that there is, it's hard for me to believe that over 10 people or more than 10 people took a whole plea deal, even Young Thug's brother. It's hard to believe they took a plea deal and nobody did anything. That would be hard for me to believe, because if they didn't believe that something was wrong, they wouldn't have took plea deals at all. They wouldn't have took any form of a plea deal. So that's my take on it. But of course, Young Thug, he has the money for somebody like Brian Steele and all them other ones sitting in the back. Those attorneys in there, those are high profile attorneys in Atlanta, Georgia. So those people back there, either Young Thug is footing that bill, or, of course, they probably got their own money, whatever, or they're probably doing it for the publicity too. So the bottom line is when you get an attorney, you guys, or if you decide to get an attorney, especially in a case like this, make sure it's an attorney that has your best interest at heart, your best interest, because I feel that between the state giving him such a raw deal in that plea agreement and his attorney not reassuring or assuring that wording was correct. Yes, Steele is dynamic. He reminds me of Proctor from Power. I don't know if you guys have watched Power, but he reminds me of Proctor so much. But if you're going to be represented in situations like this, you got to make sure that you have an attorney that has your best interest at heart, because there are certain things that they can do. There are certain law cases that they can quote, anything. Because you see, like I said, if you're not watching the trial, or, maybe dip your head in every now and then, and you will see how Brian Steele is representing Young Thug, and you will see how everything they come at him with, he's coming right back at them with something. He's gonna argue, he's gonna fight, he's gonna, right now, I think the state has a very weak case. I'm not gonna lie, their case against Young Thug is very, very weak as far as the murder. I don't think he's going to get charged with murder, but will they get him on something that has to do with a RICO? Absolutely. And the reason why is because his co-defendants took plea bargains. So somewhere along the line, somebody done said something. So I don't know. We'll see. I really don't know. We'll see, though. We'll see. They could just give him time served. We'll see. But the whole point is, you guys, just make sure that your loved ones, your kids, whoever, especially a Black man, make sure that if they're going to go out there and do a crime and participate in some foolishness, make sure they have the right representation, and make sure that lawyer is doing everything he can as far as paperwork. Make sure he's laying his eyes on that paperwork. Make sure you or your family members is laying eyes on that paperwork. Because if not, somewhere on the lines, you're going to end up missing something, and it's going to cost you in the long run, the same way it did Mr. Sledge. So that is the lesson learned for today, basically. And it just so happens that this trial happened to this trial happened to kind of back that up as to how a man can get set up once he enters the system. how it's very hard for him to get out, and he's going to get rotated right back through. So unless he just completely goes straight, stays out of trouble, does nothing. And although this dude, he really didn't do anything, he got a bad deal from his attorney. So, but anyway, you guys, that's going to be it for me for today. That was my lesson. I want to apologize about the audio. Like I said, between StreamYard and my Wi-Fi, it just ain't cooperating today. So, but at least you were able to get a gist of what I was pointing at, and just you was able to hear just enough to kind of understand what I was talking about. But anyway, I appreciate you guys coming in today and hanging out with me as long as you could. For people who came in and was more interested in this than you were, the drama that's going on. And it simply, like I said, it amazes me the attention that drama can keep more than something that can benefit somebody's family or whatever. But, it is to each his own. But thank you, CS, for coming in. I appreciate you so much. Of course, my mod latte. Hassan, thank you so much for coming in. I appreciate your support very much. Miss Judy came through and I appreciate her. Robin, thank you so much. Love Cat, Terry, Joski, Josephine, Nita, Kimberly. I thank you, Ronithia. Thank you guys for coming through and showing some love. I really appreciate you guys. And I will definitely see you guys on the next live, and we'll probably end up talking about the DA. But if you haven't seen the trial, you guys, just go check out a little bit of it, okay? So you can get an idea. It's actually very, very interesting to look at. And it really does catch your eye, y'all. It's not boring. Those trials are not boring at all. So just go check it out. And I will catch you guys the next time. See you later. You guys have a good day.